All right, so in this subsection, we're going to be talking all about kind of major U.S. Supreme Court cases that have an impact on the juvenile justice system. There's been a lot of them. I just chose kind of, 8 or 10 of the biggest, most impactful ones. But if you go looking, there are a heck of a lot more than this, right? So to start, we're going to go all the way back to 1966, a case called Kent v. U.S. And we're going to talk in the next subsection all about waivers, how in some states at a certain age, between a certain age and 18, juveniles can be waived to adult court to be tried as adults, even though they were technically under the age of 18 when they committed the crime. And it wasn't until 1966, in this case, that juveniles had a right to a hearing in the juvenile court before they get waived to adult court. So they get to kind of, the defense gets to stand in front of the judge and make their case for why they shouldn't be waived to adult court, why they should be tried in the juvenile system. And they get to at least be heard, right? That doesn't mean they can't be waived to adult court. It just means if they want to speak before a judge and make their case for staying in the juvenile system, they can. Whereas before 1966, they didn't have that option. If you got waived to adult court, you just got waived to adult court. 1967, In re Galt, was maybe the most famous juvenile justice Supreme Court case. This one came with a lot of things. In many states and many jurisdictions, instead of having like a name v. state or name v. name kind of case naming system, for juveniles, they just do in re or in regards to, and then the name of the defendant, right? So in re Galt, as soon as you see that in re, you know that it was a juvenile case from one of those states that name their juvenile cases that way. And with in re Galt, the Supreme Court ruled that there was a huge list of rights that adults had, but juveniles didn't prior to this. You do actually have a right to due process. You have a right to counsel, just like an adult does. You have a right to cross-examine witnesses. You have rights against self-incrimination. There's a whole bunch of these that got acknowledged in this In re Galt case, but not all of them. Now, it wasn't until 1970 and In re Winship that the Supreme Court ruled that the standard of finding a juvenile guilty had to be beyond a reasonable doubt, just like it is with adults. Prior to this, the standard of finding a juvenile guilty was just the preponderance of the evidence, like it is in civil court, right? Which is a much lower bar to meet than beyond a reasonable doubt. So it wasn't until 1970 that you had to prove a juvenile was guilty of committing a crime beyond a reasonable doubt in this country. But now, luckily, we do. 1971, McKeever versus Pennsylvania. And this is one where the Supreme Court came down and said there is no right to a jury trial in a juvenile court case. Because the Supreme Court, kind of their reasoning here was that we want juvenile trials to be, again, kind of focused on the juvenile and focused on rehabilitation. We don't want it to be as adversarial as adult trials. We don't want to have, all the issues that come with a jury. We want the juvenile court judge to have the kind of sole responsibility to decide guilty or not guilty in sentencing and all those things. So once again, this is that kind of parens patriae kind of doctrine coming in. We're going to trust the juvenile court judge to do the right thing rather than leaving it up to a jury of 12 members of the community. 1975, Breed v. Jones. This is where the Supreme Court finally acknowledged that juvenile court cases are close enough to adult criminal cases that double jeopardy does apply. So you can't be tried for the same crime twice in juvenile court any more than you can in adult court. So that was a big one. Now, if you'll notice, those were all kind of in the 60s and 70s. That was a huge expansion of juvenile justice rights. The early 21st century had a similar kind of expansion of juvenile justice rights. The most famous case from the early 20th century is Roper v. Simmons, which is where the Supreme Court finally said that there can't be any death penalty in juvenile cases. And this doesn't matter whether it's from the juvenile court system or the adult court system. if you were under the age of 18 when you committed the crime, you cannot be given the death penalty. And this follows a series of cases from the decade or so prior to this, where they said, no death penalty if you committed the crime under 16. Then another one, no death penalty if you committed the crime under 17. But the Roper v. Simmons one was kind of put the final kibosh on the death penalty for juveniles and said, if you were under the age of 18 at the time of the crime, you cannot get the death penalty. And I have seen so many people think, oh, you can't give the death penalty to juveniles, just wait until they're 18, then give them the death penalty. Doesn't matter. It's not that you can't give the death penalty to people who are under 18 at the time of death. It's that you can't give the death penalty to people who are under 18 at the time of the crime. And no matter how much time passes since then, the offender's age at the time of the crime is not going to change. So at this point, you cannot give any death penalty to anybody who is under 18. Now, this gets expanded in 2010 in Graham v. Florida, where it says that not only can you not get the death penalty, you can't get life without parole for any case other than homicide, right? So there is no crime a juvenile can commit other than homicide where they are eligible for life without parole. They can get life with the possibility of parole for the really egregious crimes, but they cannot get sentences of life without the possibility of parole except in homicide cases. And then that was kind of further expanded in 2012, Miller v. Alabama, where they said even for homicide, you can't have a mandatory life without parole sentence, right? So in the state of Alabama and others, if you get found guilty of a homicide, kind of the lowest penalty you could get was a mandatory life without parole. So since 2012, after the Supreme Court case, juveniles, even if they're waived to adult court, even if they're convicted of homicide, there still has to be the option to be sentenced to life with parole. They still could theoretically be sentenced to life without parole in these homicide cases, but it can't be kind of the minimum. It can't be mandatory. There has to be an option of life with parole, or even theoretically something less. All right. Once again, we're going to take a break. Thank you so much for watching.